Hello, everyone. Nice to have you back here with us again at the Public Law Parlour. As promised, this is part 2 of our episode called Decolonising Justice, the CCJ and 5 cases that shape Caribbean constitutionalism. We were quite heartened by the positive feedback that we received for part 1. We're glad that you enjoyed that particular part of this episode. So we also got some commentary where some of our listeners said that it would be nice to see us. So going forward for episode 2, we promise that you will see us, and not only see us, but you will see a very interesting guests with us as well, who will remain a mystery. So look out for that particular episode. With that being said, today we're going to finish discussing the 5 cases. We discussed 2 in part 1. We discussed the seminal case of Attorney General and Joseph and Boyce, and we also discussed the Maya Leaders Alliance case from Belize. And today we're going to discuss the cases of Nerve and the Queen, McEwen, and the Attorney General of Guyana, and also the case of Belize International Services Limited from the country of Belize. Of course, I have my co-host, my friend, and as he would say, intellectual rival with me, Mr. Ramdas. Do you have anything to say to our viewers and listeners, sir?
Right. Hi, everyone. It is a pleasure to be here for part 2 of the Public Law Parlour and the very long name which I created and now regret. But I must echo the sentiments of Rico and say that I was very heartened to see the positive feedback and how many people took an interest and watched the last episode. Rico and I actually did not think that we would have gotten that many views or that many positive comments for episode 1. And it reinforced the position that we took when we started it, that this was something that was important. And that given that we have these conversations weekly, we should probably put them out there for the benefit of the wider Caribbean law students, legal professionals alike. And with that being said, just to reiterate where we left off last week. Last week we looked at 2 cases, AG against Joseph and Boyce and the Maya Leaders Alliance case. And what we focused on in those cases was that the CCJ had slowly begun to whittle away at the idea of dualism and had begun the process of incorporating principles of international law into constitutional interpretation. This week, we are now going to look at 3 cases where Rico and I believe that the CCJ has done revolutionary things in interpreting Caribbean constitutions, sometimes admittedly very controversial and might be just overreaching beyond the bounds of accepted judicial precedent. But I'll leave that for you all to decide. But nevertheless, we'll start with our first case, a very important case from the CCJ, Neve and Severin against the Queen. Now, the facts of this case are not new or not indistinct in the Caribbean. Effectively, it was a challenge to the mandatory death penalty under Section 2 of the Offences Against the Persons Act in Belize.
In Barbados.
In Barbados, yes.
Yes.
My bad. Apologies to the people of Barbados. But this is not something that is new to Caribbean jurisprudence. If you've done constitutional law, you'll know that there's a host of cases that challenge the mandatory death penalty. What is interesting about Neve and the Queen is that both the majority and Justice Anderson, unlike the Privy Council, came to the conclusion that the mandatory death penalty was unconstitutional, even in the face of the Savings Law Clause. Now, I will let Rico tell you a little bit about the Savings Law Clause.
Very much, Alex. So what I would say, though, before I delve into the discussion about the Savings Law Clause, is that, interestingly enough, this is actually the first case going to the CCJ where the court actually had to consider the constitutionality of the mandatory death penalty. It was an issue in the case of Joseph and Boyce, but it was more of a peripheral issue in that case. But here in Nerve, the court is dealing with the issue full on, head on, and they had to determine, is the mandatory death penalty constitutional or unconstitutional? Now, there was a conundrum, and Alex alluded to it, the Savings Law Clause, which I think Justice Anderson, in one paper that he wrote, he described the Savings Law Clauses as bedeviling the Caribbean constitutions and Caribbean constitutionalism. Now, essentially, Savings Law Clause is a clause that you would find in some Caribbean constitutions, not all, some of them, primarily the pre-1973 Caribbean constitutions. And this clause, in effect, says that any laws which a country followed before independence, or in some cases, if a Caribbean country is a republic, before they transitioned to Republican status, were saved and therefore could not be touched. And the conundrum comes where this clause is saying these laws, these colonial laws, cannot be touched, even though they are inconsistent or clash with fundamental rights in the Constitution, which is kind of like a paradox. So the Constitution is telling you that you have these fundamental rights and freedoms, or these human rights, which Simeon McIntosh described as the moral core of the Constitution. But at the same time, it is protecting colonial laws from being struck down, essentially, even though these laws violate or are inconsistent with those same fundamental rights and freedoms. You may ask yourself the question about how does this make any sense? And that was essentially the conundrum that the CCJ had to deal with. So that is the effect of a Savings Law Clause. So you have the fundamental human rights in the Constitution, but you also have this Savings Law Clause in the Constitution itself, which protects colonial laws like the mandatory death penalty in the case of Nerve from Barbados. Now, obviously, you would say that the mandatory death penalty would be inconsistent with human rights like the right to life, the right to a fair trial, the right not to be subjected to cruel and inhuman punishment. But again, the Savings Law Clause is essentially saying, even though this mandatory death penalty is inconsistent with these rights, it cannot be touched. It cannot be deemed unconstitutional by a court of law. Right? So it's a very difficult and knotty issue that a court has to essentially unravel. So in this case, the mandatory death penalty was essentially a saved law, meaning it was a law that we inherited from colonial times. Now, Alex just asked me to explain what a Savings Law Clause is. So I did that, and I don't know if he wants me to do anything else, especially
No, I don't.
has a very strict timeline.
No. All right. So, no, Rico, I don't have anything to add. I think I would be proven right in letting you discuss the Savings Law Clause because clearly you did a good job. What I would add though is that what the CCJ grappled with and what even the Judicial Committee of the Privy Council grappled with from the dawn of Caribbean constitutions is that effectively you have a constitution which HLA Hart, if you remember jurisprudence called your Grundnorm, is the originating law and norm of a society that is supposed to supersede all laws. but you now have these colonial laws that in some form or fashion take precedence or are immune from constitutional review. So it was quite the conundrum that the Caribbean is placed in, because the CCJ is now put in a position where are we cursed without constitutional reform to be beholden to the colonial laws of our colonizers? And Nerve, as Rico mentioned, was the CCJ's attempt to address that. And there are many things that are of importance in Nerve. I think for the purposes of this podcast, we will focus on the two approaches taken by one, the majority, and the dissent in addressing the Savings Law Clause issue. The majority in the CCJ also spoke about the effect of Section 11, well, it's no longer a preambulatory provision based on the findings of Neve, but if you're familiar with the Barbados Constitution, Section 11 was previously believed to be preambular. It is no longer preambular. But for the purposes of this discussion, we will focus on the two approaches that the CCJ took to address the Savings Law Clause. And I think it's best to describe them as this. One, the superimposition of the independence order onto the Constitution, and two, the separation of powers argument, both of which found that the mandatory death penalty was unconstitutional, even in the face of the Savings Law Clause, but both very controversial. And I will let Rico tell you about the superimposition point, even though I could do it, but as I said, he is the explainer amongst us.
Well, I'm not sure about explainer, and I'm also not sure about superimposition. That's a very strong word, Alex. It's very, very strong. I get your point. So when Caribbean countries became independent, they were essentially given constitutions along with what we would call the independence legislation. So let's focus on Barbados, since Nerve is a case from Barbados. So when Barbados became independent from the British gave us the Independence Act of Parliament, and it also gave us the Independence Order. Now, the Constitution of Barbados, the Independence Constitution, was scheduled or attached to this Independence Order. Now, I want to make this very, very clear. The Independence Act and the Independence Order were ordinary pieces of legislation. The Constitution attached to the Independence Order, one of the ordinary pieces of legislation, was and still is the supreme law of the land, as we all know. Now, the problem arose when the Constitution, which is the supreme law of the land, started to take root and became enforceable, separate and apart from the independent order which it was attached to. Now, in the independence order, there was what we would call the modification clause. And a modification clause, in effect, states that any save law had to be brought into conformity with the Constitution through any modification, adaptation, qualification, etc. So essentially, if a save law like the mandatory death penalty conflicted with any part of the order, and remember, the Constitution at that point in time was part of the order because it was attached to the order, then that save law had to be construed or applied with the necessary modifications, adaptations, or qualifications to bring it in conformity with the order. Now, if the Constitution at that point in time was part of the order, and you have the modification clause saying that any save law meaning any law that we inherited from the British, had to be modified to be brought in conformity with the Constitution. But at the same time, you have a savings law clause in the Constitution itself saying that these laws are untouchable and must stand, notwithstanding their inconsistency with the human rights. What are you supposed to do? Do you read the savings law clause and the modification clause in the ordinary piece of legislation, namely the independence order, together? Or do you say that the savings law clause takes precedence because it is now in the supreme law of the land, the Constitution, whereas this modification clause is only in an ordinary piece of legislation, which is subordinate to the Constitution itself? So again, that is the conundrum, or at least one of the conundrums that the CCJ had to deal with. So it's a very knotty and technical area of constitutional law. So, I mean, I hope that I'm doing a very good job in terms of demystifying and breaking it all down. In addressing this conundrum, you had the majority from the CCJ, and then you had Justice Anderson in his, what I call, a very powerful dissent. Now, let's look at the reasoning of the majority first. So the majority found that you had to essentially read the modification clause in the independence order together with the savings law clause. So the majority used the modification clause to bring the mandatory death penalty in conformity with the fundamental rights in the Constitution. And by doing so, they said it cannot be read as a mandatory death penalty, but it would have to be read as a discretionary death penalty. Because if you read it as a mandatory death penalty, then it would violate, let's say, the rights to a fair trial, the right not to be arbitrarily deprived of life, etc., and the right not to be subjected to cruel and inhuman punishment. So even though the offense was that if you were convicted of murder, you shall be, and usually the word shall is mandatory language, even though it said you shall be sentenced to death, the CCJ is saying, no, you have to interpret shall to not be mandatory, but be discretionary, and essentially interpret shall to mean may. Now, that in itself is very controversial because, you know, if it says shall, then some people would say, well, it says what it means and it means what it says. So the controversial aspect of this particular point was that the CCJ used a modification clause in an ordinary piece of legislation to essentially trump the savings law clause in the Constitution, which is supposed to be supreme to and above the independence order itself.
For that very detailed explanation. As I said, he is the explainer. But what you see with the majority's decision in Nuve, at least from my perspective, is that the CCJ was caught in a rock and a hard place. Because on the one hand, a textual literal interpretation of the Constitution places colonial legislation above the Constitution. And on the other hand, you have a colonial piece of legislation that was used to bring the Constitution into life, being used as an interpretive aid. If Rico has a problem with the word superimposed, but but it raises some very interesting questions to me and has split the Caribbean down the middle on the approach by the CCJ. Because on the one hand, you have the CCJ, you have proponents of the very textual English language reading of the Constitution that say that clearly the general savings law clause was absolute in effect. And it is impossible in light of principles, the principle of constitutional supremacy, to now take a provision that was in the independence order and use it as an interpretive aid. On the other hand, and this is an opinion that I came to after some thinking and maybe playing with my initial gut reaction to the approach by the court, was that originalism and looking at the historical underpinnings of a constitution as an interpretive aid is something that is not new. It is a concept of a principle of constitutional interpretation that has existed and is actually very popular in the American Constitution. And in some ways, I view the CCJ looking to the independence order and the provisions contained therein, particularly the modification provision, as an exercise of originalism or looking at the historical nature, the historical underpinnings of the Constitution to aid in interpretation. Truthfully, while it is controversial to say that we can impose statute onto the Constitution as an interpretive aid, this is not any statute. This is the independence statute. This is the statute that brought the Constitution into being. And to my mind, just as you can say that the modification clause was purposefully left out, there's also an argument to say that it was purposely left in the statute. Now, I think that there's some level of weight to be given to the fact that the statute existed, and it's not, as they say, an ordinary piece of legislation. It is the independence order. It is the order or the piece of legislation that brought us into being as an independent state. And I think there is, even I don't want to attribute any form of super statutory power to it, to create a concept, but there is merit to saying that there is value in its use as an interpretive aid, particularly the historical rationale, or the historical nature of the statute, and the fact that without it there would be no constitution.
And I completely agree with you there, Alex. I must confess that initially, when I read the majority's decision, I didn't like the reasoning. But after much thought, I must say that I now see the merit in the majority's reasoning because, like you said, even though the modification clause is outside of the Constitution and contained in the independence order, if it is that you do not use the modification clause, then it would mean that you have an entire provision that is meaningless and useless. And I don't think that that was ever the intention of the legislative framers. I think that the modification clause in the independence order was meant to be used and meant to be used together with the savings law clause in the Constitution, but I just think that the way that they went about doing it was wrong. I think that what they should have done, and this is exactly what Barbados did after the court struck down the mandatory death penalty in Barbados, the CCJ struck it down. Barbados actually put the modification clause in its constitution alongside the savings law clause. So it's like a conflation of the two clauses. The savings law clause saying that these colonial laws are saved, but then it goes on to say that even though they're saved, they must be read or applied or construed with the necessary modifications to bring them in conformity with the Bill of Rights. And I think that is what perhaps the intention was, but it was not materialized at that point in time. Perhaps because of the legislative framers' familiarity with parliamentary sovereignty, they probably didn't see that, there would be this problem with leaving the modification clause in this ordinary piece of legislation, which to them in the UK is supreme. Whatever Parliament makes is supreme. So perhaps it was not a problem to them, or at least not to their minds at that point in time. But I think the approach that Barbados took after the CCJ struck down the mandatory death penalty in Barbados, which is to combine the Savings Law Clause and the Modification Clause and put both of them in the Constitution, is the best approach to adopt in order to avoid the conundrum to begin with. Now, that is the majority's opinion. Let us look at Justice Anderson's dissent. He didn't agree with the majority on that point, Alex, and tell our listeners and viewers why. I mean, I think you alluded to it previously when you were speaking about the effect that it could have on constitutional supremacy, etc., etc. But if you could explain a bit more.
To be brief, because ultimately it is a dissent, Justice Anderson sided with the majority in Boyson R. Boyson R. This to add some context.
Boyson R. Alex, just to interject, Boyson R. came from which court?
The Privy Council, the judicial.
Right. So just to make that clear.
Yes.
Yes.
Not to be mistaken with AJ and Joseph and Boyce. But Boyson R. was a Privy Council decision. That where the issue of using the independence order to interpret the General Savings Law Clause had been raised. And the majority in that case, to put it briefly, affirmed constitutional supremacy as a principle. And even though there was this provision in the independence order that required modification, the existence of a constitution as the ground norm that superseded all norms meant that the general nature of the wording of the Savings Law Clause in the Constitution as passed would have taken priority and invalidated any weight, not invalidate, but would have taken priority and minimized or completely negated any effect that the independence statute would have had on interpreting it. As Rico alluded to, it may have been a faux pas on the legislatures at the time of independence to believe that the statute could have had any sway on the Constitution. But Justice Anderson, and that was
Alex, now that I'm thinking about it, perhaps they didn't think that, as Simeon McIntosh put it, that the Constitution itself would have taken root, local root, and therefore could exist separate and apart from the order itself. So they probably thought that the Constitution was always meant to be attached to the order and could not exist separate and apart from the order. Who knows? Who knows?
Who knows? Maybe the Hansard knows. That might be a good experiment. But in disagreeing with the majority's approach, Justice Anderson, interestingly, did find that the mandatory death penalty was unconstitutional. Not because you could read the independence order that required modification of the General Savings Law Clause, but because the effect of imposing a mandatory sentence was considered a total usurpation of the judicial function of sentencing. And to Justice Anderson's mind, that was a separation of powers violation. And in breaking with the Privy Council's ruling or reasoning in Matthew and the AG, he was of the opinion that this was sufficient to invalidate the provision. Now, what you have in the way is two, I won't even say controversial, because if we are being truthful, the Privy Council has never been unanimous or entirely consistent in its approach to the mandatory death penalty. There have always been very powerful dissents, but the CCJ for the first time.
But I'm glad you mentioned that point, Mr. Ramdas, because a lot of people tend to forget that the majority in the CCJ did was essentially adopt the Privy Council's approach in Rudal, but the composition of the Privy Council was completely different at that point in time. And what that shows me, when you actually look at the Privy Council's decisions concerning these savings law clause issues, you would really see that depending on the composition of the panel of the Privy Council at the particular point in time, the reasoning or the decision may actually be different.
Yeah. So to get back, it was the first time that a Caribbean court had to deal frontally with the constitutionality of the mandatory death penalty, and to a more important extent, how to treat with a general savings law clause. And you saw that even if through the use of controversial legal mechanisms, priority was placed, at least jurisprudentially, on detaching the Caribbean, detaching the Barbados Constitution from the shackles of colonial a colonial view of the Constitution. Priority was placed on interpretation and the treating of your Constitution, or methods of interpretation that allowed for things that inhibited the true realization of our fundamental rights to be minimized, and some may argue completely whittled away. And I think that flows well, or is in line with the theme of decolonizing justice.
I was at you took Mr. Ramdas, you took the words right out of my
Right.
mouth. I was literally just about to say that I guess based on what you were saying, the case of Nerve best exemplifies the first part of your title for this particular episode, which is decolonizing justice. It doesn't get any better than that, I guess.
Yeah. Yes. And maybe on that point, it might be useful to segue into the follow-up case, where we see more of the same from the CCJ, albeit in a less, well, I mean, it's the second case, so in a less controversial manner. And that is McEwen and the AG of Guyana.
Very, very
Now,
interesting case, guys,
yeah,
coming out of Guyana.
yes.
When I
So
explain this to my students, they always end up laughing.
why is that, Rico?
Because you will see. You will see. I'm
Yeah,
sure when I get to the part, you will be laughing as well.
yeah. All right. But to be brief, McEwen and the AG dealt with or concerned several transgender and non-gender conforming persons who were convicted under Section 153(1) of the Summary Offences Act of Guyana, um, for being a man in any public space for any improper purpose appearing in female attire. Now, to add context, Section 153 of the Summary Offences Act in Guyana forms part of a slew of offences that are historically known as vagrancy laws. And the CCJ, quite importantly, in their analysis in McEwen, made mention of this historical reality, and that these laws initially were enacted post-emancipation as a means of inhibiting the 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 newly freed person's ability to express that freedom. You as a formerly enslaved person, you had no land, you had no money, you had no means of social advancement, and inevitably you were forced to loiter. You were forced to move away from the plantations. Not forced to move away, but if you in an effort to get away from the plantations, you would move to city centers and towns and those places. And vagrancy laws were quite clearly a way of ensuring that persons remained in the plantation. So even though you were free, you had no option or opportunity to be a productive member of society in any other way but in agriculture and back at the plantation. And what was interesting is that the CCJ mentioned that in the 60s, around labor riots and the Black Power movement, and that general period of civil unrest in America and in the Caribbean, these very same vagrancy laws were then also used or retooled to control and restrain deviance of any kind, be it by persons of color, be it sexual deviance, be it political deviance. And to me, McEwen is important because it represents, I guess, in the vein of decolonizing justice, the CCJ frontally grappling with the historical reality of these saved laws. Now, McEwen, in terms of the decision, is not.
Well, before you get to the decision, Alex, I think it's important to let our listeners know what exactly was the vagrancy or save law in McEwen that
Well,
was challenged.
I had mentioned it at the beginning, but it was Section 153 of the Summary Offences Act of Guyana, which is being a man in a public space for any improper purpose appearing in female attire.
Right.
Yes. So that was it is
And vice versa. Being
and
a
vice versa.
woman,
Yeah.
right, being a woman in any public space, dressing in male clothing for an improper purpose.
Yes.
Now,
So
there's a reason why I wanted you to essentially explain what this particular vagrancy or save law states, because that leads up well to my joke. But we have not gotten there yet. So you can continue, Alex.
right. So now that the foundation has been laid for Rico's joke, we will all eagerly await the punchline. But in effect, the CCJ and McEwan did not break from from its reasoning in Nuvei, even though they had no need to use or superimpose the modification provisions of the Guyanese independence or the Guyana's Constitutional Act. McEwan is important because I think for the first time, the CCJ elaborated upon the four ways in which general savings law clauses or these colonial law, or the provisions of the Constitution that afforded protection to laws that were enacted and created in to protect some of the most obscene parts of our colonial history. The CCJ identified four ways in which the court has now chosen to whittle away at the at the savings law clause. And these are, right, one, you interpret your clause narrowly and restrictively. Two, the savings law clauses only immunize existing laws from in relation to the stipulated human rights provisions, meaning that other constitutional principles, are not saved or not immunized as a result of these provisions. Three, it should be that you should avoid interpretation that conflicts with a state's international obligations. And four, the adoption of the Nuvei principle where possible, as a result of the modification clause contained in the Guyana's Constitutional Act, you modify the saved laws to bring them into conformity with the human rights provisions. Now, in in McEwan, there was no need to adopt the Neve approach and modify, simply because the court found that the words improper purpose were so vague that it was impossible for it to meet the muster of the rule of law. To add context to that, the rule of law, in Bingham's book, The Rule of Law, there's a principle that says that there needs to be certainty in criminal statute. And this is a principle that is more or less established and settled in law. And what the CCJ effectively argued was that there is no real way of defining what is an improper purpose. And additionally, there's no way of defining what is male or female attire, which I don't quite understand, but I get the point that there's a lot of unisex clothing out there. To the extent that
Exactly.
saying that there is male or female attire, it is a very
Subjective.
subjective, and also puts a person in a conundrum and an improbable situation where they have no way of knowing, am I violating this law? Should I choose to wear a pink shirt tomorrow? Am I in a public place in female attire? And
Exactly.
if I am now in a public place in a pink shirt selling weed, have I now committed an offense under Section 153? Because I am in a public place in perceived female attire for an improper purpose. And
Or for
the
what someone else may deem to be an improper purpose.
improper purpose, it is highly subjective. And in that sense, does not pass the muster of legal certainty that is required for the law to rule, because in order for the law to rule, you need to be certain of what the law is. And the CCJ made the point, well, this is not certain. And additionally, another point that the CCJ took that to me made a lot of sense was that if you were to interpret the Guyanese constitution and the Savings Law Clause narrowly, the Savings Law Clause applied only to the provisions of the constitution that would have existed at the time the Guyanese constitution was passed or would have come into being. Guyana has famously, has famously amended their constitution and added several rights to it, to the provisions contained therein. And what the CCJ held was that these fundamental rights are not saved, and the colonial laws are not immunized from review under these provisions, which, again, I don't think that's very hard to get behind, or is certainly not a disagreeable approach. So to me, McEwan it's not a case of there was nothing new that was established in McEwan more than it was a continuation of the general approach of the CCJ to whittling away or addressing frontally the difficulties posed by colonial legislation and our colonial past. And maybe it's time to pass Rico on to see if he could drop his wisdom and this joke that he has me.
Well,
Curious
not
about.
wisdom, not wisdom, Alex. I think you did a fantastic job at sharing the wisdom there and actually breaking down the different aspects of the case. Now, for my joke, I actually watched the live hearing of the McEwan case, and Alex just explained what the law that was being challenged said. It essentially said if you were a male wearing female clothing in a public place for an improper purpose, you were violating the law, and vice versa. If you were a female wearing male clothing in a public place, for an improper purpose, you were violating the law. Now, and Alex also spoke about the principle of legal certainty. If you're going to create a criminal offense, especially a criminal offense which will impinge on the fundamental rights and freedoms of individuals, that criminal offense must be as legally certain as possible, meaning that all individuals, all citizens subjected to this offense must know or must have sufficient or reasonable notice of what is required for the commission of this offense. That is the principle of legal certainty, right? The law must be as certain as possible so that you could take steps or measures as to avoid committing the offense or breaking the law. So, as Alex said, when I was watching the live hearing of the McEwen case, I remember the CCJ asking, I think it was Justice Saunders in particular. Justice Saunders asked counsel, the attorney for the state, what is an improper purpose? And there was this pregnant pause. And I mean, I was there watching and waiting and listening intently to hear how he was going to define an improper purpose, because I thought about it long and hard. I was like, how do you even define what an improper purpose is? And the attorney for the state said, Your Honors, an improper purpose is a purpose that is improper. And he said it loudly and confidently, and all I could have done, and I think even the entire bench of the CCJ, all the judges at the CCJ laughed, and that's the same thing I could have done, because he could not define what an improper purpose was without using back the same words. And that in and of itself shows that there was no legal certainty to the offense created under that law. If you can say that an improper purpose is a purpose that is improper, that took the court nowhere. So that was my that was my joke that I wanted to share with our listeners and our viewers. But I do agree with you, Alex, that the McEwen case is another important case as it pertains to decolonizing Caribbean constitutional law and justice in the Caribbean, definitely. So I guess now that, Alex, we can move on to our fifth and final case,
Right.
and perhaps your favorite case. So I will let you take the lead on this one yet again, because I
Yes.
know that
But
you
I
have a
would,
very
I
soft
mean,
spot for this one.
I wouldn't say it is it isn't my favorite case. I just think it is interesting, and not for the case itself. If we're being honest, this was a a breach of contract case that had some constitutional undertones, but there is a lot of value and analysis to be found in the concurring judgment of Justice Jamada. And this case, as we had mentioned before, is Belize International Services Limited against the AG of Belize, um, which effectively dealt with the Belize International Services Limited, which was a company that operated two registries in Belize. And in 2013, the government of Belize took legislative action to terminate the management contracts of BISL. It was a case brought by BISL for the breach of that contract and what would have been presumably an improper taking. But what the majority in their case obviously found for BISL. But what is interesting about the BISL case is the concurring judgment of Justice Jamada, who, some might say on a frolic of his own, decided to, to introduce into the court's jurisprudence the basic structure doctrine, a principle of constitutional interpretation that is very controversial and rooted in Indian jurisprudence. And I think it's worth mentioning
But you
because
first have to tell our listeners, Mr. Ramdas, why this doctrine is so controversial. I want to
well,
know too.
I am getting there, Mr. Yo, I am getting there. Um, it it is rooted in Indian jurisprudence and is quite controversial. Because what it effectively champions is the notion that there are certain elements of a constitution or certain aspects of a constitution that are supra-constitutional in nature, to borrow Mr. Yearwood's words. Meaning that,
Not my words,
my words,
not my words, Alex, not my words. The Privy Council's words.
yeah,
The Privy Council's words, Mr.
right.
Ramdas.
And what that means is that there are certain principles found in your constitutions that can supersede even the written text. And even though Justice Jamada's decision was a concurring decision and was not accepted by the majority in BISL, I think it's important because it introduced into the discussion, and I think he's quite correct, um, an analysis of what the CCJ has been doing since in its effort to decolonize. And that is effectively identifying that there are certain basic core principles that you that supersede the written text of your constitution. Just, I mean, if you speaking loosely, if you look at even Justice Anderson's dissent in Nuvei, the idea that separation of powers invalidated the mandatory death penalty and the use of separation of powers as this overarching principle at variance with the court's finding in Matthew is, in some form or fashion, a manifestation of the basic structure doctrine. The court has not identified it as the basic structure doctrine. They have not called it the basic structure doctrine, but in effect, they have applied it. Um, and I think it is important to acknowledge, I guess, that it is now a principle that has been introduced into the CCJ's jurisprudence, and it seeks to identify or or Justice Jamada, he did a really nice presentation in Belize after the ISL, um, where he sought to basically draw reference to a host of decisions from the CCJ, where I think quite correctly he made the point that in pursuit of living tree constitutionalism and the reference or the insistence on the roots of the Belizean constitution, he the CCJ has now ventured a, a, into the territory of acknowledging or identifying principles of supra-constitutional importance.
Yes, and I do agree with you, Alex. I think there is merit in the basic structure doctrine. I I don't
Well, I
think
mean, to be clear, I don't think I haven't come down on one side or the other on whether I agree or not. I am
well, I,
saying
I
that,
am telling you, and I'm
yeah,
also telling our listeners that I am coming down on one side. I
okay.
think there's merit in the basic structure doctrine, and I do not think that it can be denied that there's certain fundamental or cardinal principles that actually form the basis of our constitutions. Examples would be, like you mentioned, the separation of powers, the rule of law, judicial independence, due process, all of these fundamental constitutional principles, which Some, yes, you may find reference to in the text, but others you may never see any reference to them in the text at all. But nonetheless, they form what we call that basic underlying structure of the constitutional text. Now, I find merit in the basic structure doctrine for, many reasons, but I'm just going to state a few. Now, I do understand that based on your recent judgment from the Privy Council concerning the mandatory death penalty in Trinidad, which is the case of Chandler and the state, the Privy Council is saying that you cannot use principles like the separation of powers or the rule of law as these supra-constitutional principles separate and apart from the text itself to invalidate legislation or some executive action. Okay, fine. But when we look at the British Constitution in and of itself, it is primarily made up, again, the British Constitution, as you mentioned in part 1 of this episode, Alex, is an unwritten constitution. So they don't usually have constitutional texts like we do in the Caribbean. And because the British Constitution is essentially unwritten, it is primarily made up of what, Mr. Ramdas?
Unwritten principles.
Exactly. The same unwritten principles and conventions you are saying cannot be used independently to invalidate legislation. So to me, is a bit of hypocrisy from the Privy Council, I must say. And not only that, but the same Privy Council, and this is why I always say that the opinions and rationales of the Privy Council vary with its composition. The same Privy Council, in cases like Hines and the Queen, which we all know is almost like the foundation of Caribbean constitutional law, Hines and the Queen, another case like DPP and Mollison, the same Privy Council essentially or primarily relied on principles like the separation of powers to invalidate legislation. Now we have a different Privy Council in 2022, 2023, whichever year Chandler was decided in, now telling us that you cannot use the same principle that the Privy Council utilized years before to invalidate legislation. So again, it's a bit of hypocrisy and also inconsistency. That is one. Two is, this is another reason why I find merit in the basic structure doctrine. And that is because I just want to use an example. Now, we know, or we should know, that our constitutions, at least the texts of our constitutions, actually do not prevent Caribbean parliaments from either repealing or altering provisions in our constitutions. Now, strictly speaking, any provision in the Constitution can be altered or repealed. So technically, if a Caribbean parliament wanted to repeal all the provisions in the Constitution, it certainly has the power to do so, believe it or not. There's nothing in any Caribbean constitution preventing a parliament. I mean, it's highly unlikely, but this is just a hypothetical. There's nothing in any Caribbean constitution preventing a parliament from repealing all of the provisions in that constitution, including the fundamental human rights and freedoms. Think about that. Now, if that is the case, and let's say something like that had to happen, again, highly unlikely, but hypothetically, if something like that had to happen, are we to say that we are no longer left with any constitution because there's no longer the text? Or are we to adopt a position similar to the UK and say, well, we don't have the text, but now we have an unwritten constitution because, yes, you may get rid of the text or certain parts of the text, but you cannot get rid of these fundamental constitutional principles like the separation of powers, the rule of law, judicial independence. While the text or aspects of the text can be repealed, these principles cannot be repealed. because you just can't. You can't go to Parliament and say we're voting to repeal the separation of powers doctrine or the rule of law. It defies logic, right? You just can't do that. Now, that is two. Three, I'm going to give an example now. Let's say, for instance, and this comes back to the power of Parliament to change, amend the Constitution, the constitutional text. Let's say, for instance, that a Caribbean government goes to Parliament and decides that it will be solely up to the Prime Minister to determine who gets judicial appointments. In other words, the Prime Minister single-handedly determines who the judges of a particular country will be. There's nothing, again, in the text preventing the Prime Minister or the Prime Minister's cabinet from amending the constitutional text to reflect that. But is that something that we should allow when we know that if it is that the Prime Minister single-handedly selects judges who are supposed to be the guardians of the Constitution and who are essentially supposed to act as a bulwark against executive power or the abuse of that power, if a Prime Minister single-handedly selects judges, are we just supposed to say, well, the constitutional text allowed it, and therefore it has to be constitutional, it has to stand, when we all know that that runs counter to the same constitutional principles like separation of powers, rule of law, judicial independence, etc.? And my answer is the constitutional text would have to be invalidated by virtue of the rule of law, separation of powers, judicial independence, etc. Because it just wouldn't make sense to say, yes, the rule of law exists, the separation of powers exists, but yet the constitutional text allows the Prime Minister to single-handedly choose who judges will be. I mean, you have to choose one. It's either the text prevails or these constitutional principles prevail. And I am of the view that if there's a conflict between the constitutional text and these constitutional principles, the constitutional principles should prevail. And this comes, Alex, to the question of whether the Constitution can be inconsistent with itself and whether you could have unconstitutional constitutional amendments. And there are quite a few scholars who actually wrote about this, the whole idea of unconstitutional constitutional amendments. So I do support the basic structure doctrine.
So, I mean,
and another aspect of the Belizean case that I like is that it shows that there could be that intersection between private law, because that was a case fundamentally about contract law, which is private law, and public law. And you see how Justice Jamadar infused the public law flavor and
I think
aspect
Justice
to that
Jamadar
private law decision.
took the opportunity to give a treatise on state obligations under our constitutional supremacy and tie his whole
Yes,
basic
yes,
structure
yes.
doctrine into it. I mean, you know, I don't begrudge him for it. It's good reading. But I am largely in agreement with you. I am, unlike you, I am not firmly on the side of the basic structure doctrine. I think you raise very good points that I really can't disagree with. I think
And that is quite
my
rare. I must
yeah
tell our listeners that it's quite rare that I can raise points that
yeah.
Alex cannot rebut. So I
But
actually feel very proud of myself for that.
I think my real concern with the basic structure doctrine is that, to be blunt, words in a constitution have meaning. And the words in a constitution set the parameters for which the constitution is to be interpreted. And while I hear you, the truth is aspects of the basic structure doctrine are undefined, and they are relying on principles that in and of themselves are undefined. Due process of
And,
law is not a defined principle.
and
Protection of the law is not a
I
defined
must
principle.
confess,
Yeah.
I must confess, the same way how you had to confess that I raise good arguments, I must confess that those are legitimate concerns. I do
Yeah.
understand because
Right.
I myself have thought about them as well. Like for instance, the rule of law. The rule of law is so vague, so nebulous, and it doesn't really have any, parameters, so to speak. And these constitutional principles are actually developed and conceived by judges themselves. So then you run the risk of allowing judges to determine how far we go in actually applying
Yeah.
these vague
Yeah. So I
constitutional
think, yeah,
principles. So
so that
it is a
brings us,
legitimate,
yeah,
it is a
yeah.
legitimate concern, but I don't think that the concern is so overwhelming for me that I not support the basic structure doctrine at all.
No, I think I largely come down on your side of the equation. I think it's just important to be mindful of the fact that all of these principles are largely undefined. And what you run the risk of doing, as you mentioned, is that an individual judge or an individual panel of judges now become the sole arbiters of what the contours of the basic structure is. Um, and that is something that is, dare I
Concern.
say, concerning and highly, highly undemocratic. Because as you raise the issue of the Privy Council's approach changing depending on the panel, there's nothing to say that the approach of a CCJ will change
That
depending
is
on the
true.
panel. And you
That
don't
is
want
true.
a situation where the contours of your constitution or its basic structure now become this malleable concept that can shift in small ways or even large ways, depending on the jurisprudence of an individual judge or individual bench. And I think that is where I I have my reservations about the wholesale incorporation. I mean, admittedly, it has not been incorporated, but I think there's merit in Justice Jamada's reasoning, if you read it, is that you might not agree with me that there's no basic structure endorsed, but for all intents and purposes, that is what we've been doing. We've been looking at these principles and imparting these, not imparting, but employing the overall spirit of the Constitution to come to conclusions in McEwen and Nove, even in Boyce, Maya Alliance. And there's value in it. But
I mean, that I do understand what you're saying, and that is why, like I said previously, it is a legitimate concern. And to even buttress your concern, and is quite hilarious because Justice Jamadar himself asked this question in another case. I think it was a case of Dumas from Trinidad. I stand to be corrected. But he asked the question in a case, who guards the guardians? And is something, and he when he asks who guards the guardians, he means, well, the judges are supposed to be the guardians of the Constitution, but who guards the judges to ensure that they're also acting in alignment with the Constitution itself? Because make no mistake, we all know that judges must also follow the same constitutional principles like the rule of law, separation of powers, etc. So it's not that they are, not they're immune to these constitutional principles as well, because they must follow them. But who is there to ensure that the judges are kept in check and they don't essentially run amok when they're interpreting Caribbean constitution? So it's a valid point. It's a very valid point, and I do take the point,
but
Mr.
but
Ramdas.
but nevertheless, that brings us to the end of our 5 cases.
Yeah,
And I hope in some form or fashion we having gone through AG and Joseph and Boyce, the Maya Alliance case, Nove, McEwen, and BISL, we have been able to show that there has been, not even gradually, but in a very strong, aggressive, at times controversial, but all in the spirit of decolonization, a concerted effort to grasp or identify or form a, a true Caribbean jurisprudence that breaks with the established precedent of the Privy Council. And I mean, for all intents and purposes, that is what the CCJ is there for. It makes no sense you empanel a CCJ and create a court if there's going to be no effort to break with the accepted norms of our colonial court. Even if you find agreement with the principles, the need for the Caribbean to fashion principles, change principles, amend principles, and develop our own body of jurisprudence is important. And this 20 years after the CCJ's formation represents, at least in our minds, the beginning of the efforts of crafting autochthonous jurisprudence. And I'll pass it over to Rico to say his farewells.
Yeah, so we've come to the end of what I would say was an enlightening, and even for me, hearing some of Alex's views was quite enlightening. So I would describe it as enlightening, exciting, and insightful episode. And we do look forward to discussing more burning and important issues in Caribbean public law, constitutional law, human rights, sometimes even CARICOM law with all of you. Do not forget to like our videos. Do not forget to share. Do not forget to subscribe. We've been appreciating all the feedback so far. We love you. We appreciate it. We welcome even constructive criticism. We welcome that as well. And like I said, our next episode will be even more interesting, as we will have an interesting guest and also a very mysterious one. So stay tuned. And this is it for now from both me and Alex. We are now going to leave the Public Law Parlour, and we will rejoin you next time whenever that will be, but we will surely not keep you waiting too long. Thank you very much, guys, and I bid you all adieu.
Farewell, guys.